It's a sign of urgency, a key moment when a federal appeals court in California hears oral arguments on the phone on late Tuesday, lawyers from the U.S. Department of Justice facing off against those representing two states. Justice's lawyers are making the case that a Seattle judge's halt on the Trump administration's travel ban on people coming from 7 predominantly Muslim countries could result in national security risks and harms that cannot be undone. But the states say scenes like this of immigrant families reuniting at U.S. airports are what America is all about and should be allowed to continue. Let's look at the scenarios for how the situation could play out. Courts could determine the constitutionality of the administration's travel ban later. Right now, though, the Ninth Circuit Court of Appeals is deciding whether the Seattle judge who issued the restraining order against the government on Friday abused his discretion. Justice's lawyers argue that the states have no basis for challenging the denial of visas of entry for foreigners. The states, supported by the Attorney General of more than 16 states, argue otherwise.
We think the law is clear that we have the standing to protect the business and other interests of our states.
Interests like loss of tax revenue, interference with businesses in their states, and separation of families. The Ninth Circuit Court could decide to overturn the Seattle judge's restraining order, maintain it, or, as a compromise, modify it, perhaps allowing entry of foreign citizens who had previously been admitted to the U.S. or wished to return. Whatever the judgment, the losing side could appeal to the U.S. Supreme Court. An emergency stay of the appeals court ruling would require agreement from 5 justices. Still down 1 justice, the court is split 4-4. A tie would mean the 9th U.S. Circuit Court's decision, whatever it turns out to be, stays in place.